Mr. Croton, who was separated from his wife, fell in love with Mrs. Helena Webster, a divorcee. He was a mechanic, and in the 1960s, a mechanic earned enough to support a family. She was a school teacher, and she was also receiving alimony from her former husband. They decided to live on his wages and to put her wages and some of her alimony in a joint bank account. After some time, they had saved nearly $1,000. That doesn't sound like much now, but remember that in 1967, the average weekly wage was about $57. So it was a fair chunk of money. Unfortunately, the two had some sort of falling out. Mr. Croton then went to the bank, withdrew all of the money, and placed it all in a bank account in his own name. She reported him to police, and he was charged with larceny and convicted. He appealed the conviction. The High Court overturned the conviction primarily because the wrong charge had been chosen. Chief Justice Barwick said, "Larceny consists in the taking and carrying away of the property of another without his consent, and without colour of right, intending at the time of the taking permanently to deprive the owner of that property. It follows that there must be what is called an asportation. Therefore, apart from any special statutory provision, larceny can only be committed of property which is capable of physical possession and removal." He went on to say that because larceny required carrying away or asportation, it was an offence against whomever was in possession of the things allegedly stolen. In the case of money put into a bank, the bank was in possession of the money and could do whatever the bank wanted with it, as long as the bank was ready to repay that money if the account holder wanted to withdraw it. When Mr. Croton withdrew the money from the joint account, the money passed from the bank's possession into his possession with the consent of the bank. In this view of things, Mrs. Webster never had possession of the money, so it can't have been stolen from her. Had Croton been charged with fraudulent misappropriation, he'd probably have been convicted. But this case shows that larceny requires asportation, or carrying away, and it is an offence committed against the person in possession, not necessarily against the true owner.